I venture to guess that if you went to just about any jail or prison in the United States, you'd find that a substantial percentage of the incarcerated prisoners in this country were sexually abused when they were young. And who knows what happens if they were never sexually abused? Would they still be in prison? Who knows? But right now the country's going through what you would call a reckoning of sorts. And this Boy Scout settlement sets back those efforts a good 2 decades, at least.
All right, folks, it's time for our favorite podcast, Cut to the Chase. We brought back Jason Joy and Curtis Garrison to talk about an update on the Boy Scouts litigation. A lot of you have been following this. I think is the third time I've had Jason on, and now the second time with Curtis, and got a lot of comments, a lot of questions, because very complicated case procedurally with appeals, the bankruptcy. And, Curtis has been doing a lot of advocacy work on sexual abuse, and has had a couple of interesting legislative victories that I think are going to serve the public interest. How are you guys doing? We're going to get into all of this right now. So,
Ready to go.
All right. Thanks for
let's
having me on
start with the
again.
law. Jason, why don't you update us? The Third Circuit Court of Appeals made a decision.
Yes, finally, the long-awaited decision by the United States Third Circuit Court of Appeal in the Boy Scouts bankruptcy, which was, by the way, stayed or sidelined for a period of time in light of the U.S. Supreme Court decision in the Purdue pharmaceutical case. Well, that decision in Purdue was issued about a year ago, last June, and in that case, the court ruled that the plan in Purdue was illegal because it contained unauthorized third-party releases. Basically, not only was the debtor getting a release from liability, but all of these other entities that were also liable or even more liable than Purdue were getting a pass by virtue of the plan of reorganization there. And similarly here in the Boy Scout plan, you have the Boy Scouts of America. They're the debtor that is in bankruptcy. Not the local councils, not the churches, the schools, the sponsoring and chartering organizations that have at least equal liability for the abuse that happened, in the vast majority of instances. So, the Third Circuit ruled that, basically they ruled in favor of the Boy Scouts, unfortunately. They, and interestingly, the court didn't even get to the merits of the case. The court essentially said that too much time has passed, that the plan, which went effective when the district court approved the plan. So that was back in, I believe, March or April of 2023. The way that this plan of reorganization, or basically the settlement for the abuse claimants, the way that the plan was structured is that it became effective whenever the district court approved the plan. So you have the bankruptcy court that confirmed the plan. Then the first level of appeal is up to the district court, what would normally be the trial level. So once that Article 3 judge approved it, that's when the plan went effective. Well, the problem there is you've got a lot of other parties that have substantial rights that they're seeking to vindicate. They don't agree with the plan. So, they're appealing it up to the Third Circuit. Well, in the meantime, this plan goes effective. The trustee, Judge Barbara Hauser, she was appointed to basically implement the plan. All the stuff that's, everything that's written in there, the eligibility requirements, taking control of the money, opening up bank accounts, hiring the professionals in order to implement the plan. All that stuff started soon after it became effective. And so that, so it's been going on for more than 2 years now. And of course, the Third Circuit appeal, like I said, it was stayed in light of the Supreme Court granting cert or agreeing to hear the Purdue pharmaceutical appeal. So it kind of begs the question, why did they even stay the Boy Scouts appeal pitting Purdue if they weren't going to follow Purdue in the first place? I mean, clearly the Supreme Court said that the plan, it's illegal. So in order to maybe get around the clear holding of Purdue, the Third Circuit panel here, which consists of just 3 judges, 2 out of the 3 judges said that it was that statutory or equitable mootness basically precluded them from overturning the plan. Basically, the genie's out of the bottle. There's nothing we can do. If it was, if the plan was confirmed today, it would not be confirmable, or basically, this wouldn't fly. So, yeah. So right now we're stuck with what I think is maybe the worst settlement in, the history of American jurisprudence. Certainly, mass tort settlement. I mean, look at other recent settlements in similar sex abuse cases. And then last time we talked about USA Gymnastics. Since then we've had another large settlement that was in LA County recently. I believe it's about 6,000 or 7,000 victims that are splitting about $4 billion. So do the math. That's well over $500,000 apiece. Here, you've got 58,000 claimants that submitted matrix claims. As of right now, the bankruptcy trustee has finished review of about half of those, and based on our math, and certainly with our cases, the average claim amount is well over $500,000. In fact, it's close to 600,000 about this point. So, I mean, and Curtis, Curtis and I talk about this probably daily, and we have for the last 6-7 months. I mean, how much money is this plan going to cost? So, if you take every case that's determined eligible and you add up how much it was determined eligible for, so this one's 450, this one's $1 million, this one's 2 million, this one's 25,000. Add it all up, how much is that going to cost? Well, based on our math right now, it's going to be about $30 billion. And I mean, hopefully it's a bit less. Who knows? But this settlement's only $2.5 billion. So it's grossly underfunded. And another ironic part about this is, even during oral arguments in November, the Boy Scouts continue to maintain that their big argument as to why the Purdue pharmaceutical case didn't apply to this case, to the Boy Scout case, is because everybody's going to get paid in full. So I guess their logic was no harm, no foul. Everybody gets paid in full. Well, that's not correct. It's not even remotely correct. I mean, anybody that's kind of followed the Boy Scouts settlement by now knows or should know that if you're determined eligible and you sign a release, you're going to get paid a whopping 1.5% of your claim value. So if your claim's determined eligible for $1 million, your attorneys are going to get a check or a wire transfer rather for $15,000. So after attorney's fees, litigation costs and expenses, when litigation costs and expenses, typically at least a couple of percentage points. Just in our firm at least, you have experts, you have all sorts of costs and expenses. There's typically a few points right there, but you're not going to get very much. Let's put it that way.
Okay, it's a lot to unpack. I know you're living this. You guys both are very passionate. So Curtis, we're going to hold off on you for right now. Let's talk about the funding. How can you have a settlement of $2.5 billion, which is the total amount that's going to be divided up by these 58,000 victims? How can you settle for that amount and then not have it funded?
Well, unfortunately, lawyers representing a substantial majority of the abuse claimants, and go back, there were about 82,000 proof of claim forms filed in the bankruptcy court prior to the bar date back in 2020. And so you've got, maybe a half dozen law firms that represent probably 70 to 80% of all those claimants. They recommended that their clients accept the deal, accept the plan. And, just kind of start doing that math. I mean, you've got firms out there that are representing 6,000, 8,000 claimants. And I don't understand how any firm could adequately represent that many people, but hey, what do I know? But yeah, and many of those same firms were involved in the Purdue litigation. It's, basically, which is why this settlement so closely mirrors the Purdue settlement, and it suffers from the same defects as Purdue, which, by the way, a lot of people were saying, oh, if you don't approve the plan, this is the best we're going to get. And if the plan doesn't get approved, then everybody's going to get nothing. Well, that's not true. That's a lie. Okay. And that was the same arguments that in doomsday scenarios that were voiced in Purdue, even at the Supreme Court stage. Oh, your honors, if this thing's overturned, everybody's going to get nothing. Well, even before the Third Circuit issued their decision a couple of weeks ago, the Purdue pharmaceutical case had gone back. It was renegotiated. There's a lot more money on the table, and now they're seeking approval for that. I mean, what we would like to have seen in the Boy Scout case, which, by the way, it's still not over. There's still a motion for rehearing was filed with the court last week or week before, and I think there's a reasonable possibility that the entire panel of judges for the Third Circuit, which is called rehearing en banc, which is, you're asking the entire panel of the entire Third Circuit, I believe it's maybe 15 active judges right now, to rehear to rehear the case. And it's rarely is that granted, but it's reserved for, exceptional cases of major importance. And so I think this case clearly fits that description, certainly with the novelty of arguments, and in light of the Supreme Court's decision in Purdue Pharmaceutical. Just a new world out there, certainly in bankruptcy law. So there are some things that the Third Circuit needs to confront there. I would really like it if the court got past this mootness argument and addressed the issues at the heart of the dispute. There's just simply not enough money in there, and there's not even close. And the fact that the bankruptcy court made findings of fact otherwise, I believe those were just clearly erroneous. And then you're seeing that play out now. I mean, a lot of the arguments that are put forward at the confirmation stage. Yeah, Your Honor, there's going to be enough money to pay everybody in full, but you don't know that. You're asking for confirmation now. Yes, approve this, and then in a couple of years, when it turns out, oh, there's not enough money, everybody's like, oh well, we tried. Oh shucks, we got our money. Everybody else gets screwed. That's bullshit. But excuse my language there, but it is. I mean, this is the largest, most important sex abuse case that maybe, you're not going to have a larger sex abuse case, just, practically speaking. There's not going to be any other national organization that's going to, be subject to something like this where you have this many claimants. So therefore, it's even more important that you get this right. And I just think that this is about the worst settlement you could possibly have. And there's so many reasons for that. I can go into that later if you want, but litigation finance is, top of the chart there, top of the list. But yeah, as of right now, talk about funding. I mean, there were a couple $100 million that were put into the trust whenever it became effective. I don't know, 500 or 600 million. The trustee's office has, I think, something about 100 and maybe 110, 120 million dollars already in administrative expenses, which is a lot of money. I mean, Greg, Curtis, I think we could have done it for half that, the three of us. But so that's eaten into that. There have been payments, which are the initial distributions of 1.5%, totaling maybe 150 million at this point. The expedited distributions were not, and that was relatively de minimis, but there has been some money put back into it. I know that there's interest running on some of that money. I know that there's also real estate sales and things like the Norman Rockwell paintings that the Boy Scouts contributed. But again, that's about enough to simply cover the administrative costs of this. So you're going to be left with a program that, it might pay eligible claimants about 10 cents on the dollar. And I would hope it gets there. My math, it might not even get there. Who knows? I mean, we have noticed that the way that the claims administrator, the eligibility notice that at least our firm is getting back, those tend to be in states with the open window. So you don't have a huge deduction for statute of limitations. And so hopefully, the average eligibility price is going to go down a bit after that. But again, who knows? They might just be doing that with our firm and not other firms. I don't know.
Okay, funders, we're talking about insurance companies.
Well, no, the insurance companies that was part of the settlement. That's part of there's about $1.5 billion that's been sitting in escrow for the last 2 or 3 years since the effective date. That was the Hartford and the Chubb settlements. There might be another one in there. It's not that big, but really the Hartford and Chubb, those are the two big ones. And I understand that that's been generating interest. So at least we're in a relatively high interest rate environment. So hopefully that 1.5 billion has earned a little bit. I would imagine another couple $100 million. Because look, every couple hundred million counts. Let's face it. When you're dealing with such a little amount, such a small amount of money to pay for, what very well may be $30 billion in ineligible claims. So,
Okay. All right. So the difference between this case and the Sacklers is the fact that the Sackler settlement never went into effect. In other words,
Supreme Court
people were
reversed
not
it.
getting paid. They were not starting the settlement process. Whereas in the Boy Scouts, that began to some degree.
It did to some degree, but on the other hand, everything that the claims administrators has had to do to this point, they have to do that anyway. It's not as if you're going to have to restart and redo it all over. They should have been doing this 2-3 years ago. They probably should have started this in 2021. Start taking cases. Is this eligible? Is it not? What state's it in? Those basic kind of things right there. Because since then, we've probably had 10 or 15% or more of our clients have passed away since then, which causes all sorts of other problems. It doesn't mean that the client can't recover or their estate can't recover. It just gets a lot harder after that,
Yeah.
particularly if we haven't gotten all the documents and evidence that we need by the time they pass away. Because, unless you've got direct evidence, evidentiary rules, prevent the son or daughter from saying, my father told me this happened. That's inadmissible, just basic evidence.
Yeah. All right. So the commonality between the Sackler settlement and this settlement, in terms of like legality, is the fact that you had parties to the settlement. In other words, either people or companies that that had essentially agreed to cough up some money, and they're getting released by the bankruptcy court, even though they did not have to go through the bankruptcy process. In other words, they did not have to show all their assets and say, hey, this is all we have.
They did not have to bend over.
In exchange for that, we're
Yeah,
going
they didn't have to put all
bankrupt.
their assets on the table or anything like that in order to get the release. In Purdue, in that case, you've got the Sackler family. That was the party that was trying to game the system. The Sackler family, those weren't some just, oh, we're just the innocent owners of the company. The facts are, those family members were there for the ride-alongs with the drug reps. They knew exactly what was going on. We're getting people hooked on these drugs. We are making a ton of money doing it. It's not a high probability that these innocent people are going to get hooked on drugs. It's like a 90% certainty that this is going to happen. And all the damage and heartbreak and just stuff that causes, not just to the family, but to society in general. And they did it anyway. And it went on for decades, even after they pleaded guilty twice, I believe, to, criminal charges. The Sacklers, after they did that in 2007, I believe, they just restructured things to where all the free cash flow from Purdue would immediately flow offshore to these spendthrift trusts in like the Jersey and Orkney Islands and all these places where, it's very difficult to trace or impossible. And they did that until basically they couldn't do it anymore. And they filed bankruptcy. They put Purdue into bankruptcy. Now, when you start talking about Purdue and the Sacklers' potential liability, I believe the U.S. Bankruptcy trustee pegged that civil liability to all the families that have suffered and all the people that have suffered because of addiction caused by OxyContin. And I believe the U.S. bankruptcy trustee pegged that at somewhere between 15 and 18 trillion dollars with a T, trillion. So there was never, in no world were the people that had claims against Purdue and or the Sacklers going to be made whole. Now, the Sacklers were looking for a release where that entire family would get a release from all liability, even though they're not debtors, even for things like, fraud, intentional conduct, things that just aren't dischargeable in bankruptcy. You don't need to, you can't go and shoot somebody and then say, oh, I'm going to file bankruptcy. So, I don't have to pay you, in addition to serving time in jail or maybe the death penalty like that. You can't get away from civil liability just by doing that for intentional conduct or conduct that's basically criminal. So, here with the Boy Scouts of America, they're the debtor. They're the ones that filed bankruptcy. The local councils, churches, schools, chartering, sponsoring organizations. Okay, these are they're not debtors, and they're also in most cases, and we have a lot of, we handle a lot of these sex abuse cases. Those would normally be our targeted defendant. that's the boots on the ground. Those are the organizations that are actually employing the people that ultimately turn out to be the abusers. Those are the organizations that are in the best position to mitigate the damage. Those organizations are basically getting a get out of jail free card in exchange for offering very little or nothing to this settlement.
Yeah.
And so you're releasing all these people who otherwise we would be able to go get more money from these other organizations. Okay, Boy Scouts are in bankruptcy, but you're not. We can't do that now because of this Boy Scout settlement. So it's extremely, Greg, extremely frustrating. I've never been in my entire career. I've never been this frustrated and upset in my life. Just
okay. So I was, and I know this is, I'm not nearly as knowledgeable about these issues as you, but I was, in terms of funding, I just was either presuming or hopeful that once the appellate proceedings were finalized and ended, that at that point the insurance companies would kick in more. They'd say, all right, it's done. Now we're going to fully fund the $2.5 billion settlement. True or false? Is that right? Or maybe partially
like I
right?
said, I mean, there was an initial 500 or 600 million that was put into the trust when it became effective. There's about, I think, 1.4 or 1.5 that was set aside in escrow, waiting for the deal to become final. So once a final non-appealable order is in that says, all right, this plan that was confirmed, it's been upheld on appeal, and now it's fully final. Now everything can fund. So whenever that happens, if that happens, and it's looking increasingly likely that it will, then that money and any interest that accrued on it, I'm not quite. I've heard that there's maybe an additional 200 billion on top of that. I'm not quite sure. Then all that money will go into the trust, and then once all of the claims are fully resolved, the trust will make a second distribution. So you'll get your initial distribution, which is 1.5%. And then there's going to be another distribution. There's probably going to be several distributions. And there's a good chance this thing's going to have distributions going out many, many years. But you would think the biggest distribution is going to be the second one. And that's going to happen once, again, assuming you have a final non-appealable order. And then once the trust fully resolves all the 58,000 matrix claims. Then, like I said, the trust is about halfway through right about now. And in all likelihood, we'll be done by the end of this year.
Yeah.
So we're not looking at years from now.
Okay. Just to simplify the remaining part of the litigation, right now, the Third Circuit, they had 3 of their judges. That's the normal way that they proceed, even though they have 15 potential judges. So they made their decision. And then as a matter of procedure, the losing party can ask the entire panel of the 15 judges to rehear the case.
Correct.
And that
We're hearing
is,
en banc. That's
we
French.
call that en banc, and that's not likely unless it's a high profile case, which this is.
Yes, and I think there's, again, I think I'm the only lawyer that's been hoping for this thing to get overturned from day one, and it looked like it would for a while. I mean, the Third Circuit held on. The oral arguments were in November, and they didn't release this thing until May.
Yeah.
When it was not released by March, people started getting, hey, this thing's going to get overturned. I thought personally that they were just holding it, waiting till all matrix claims were
scored,
were adjudicated, and then they were going to overturn it, and then allow people to. Well, I don't even need to get into it, but yeah. So you've got rehearing en banc, and yeah, this case does meet what is typically considered by the courts whenever they decide to grant rehearing en banc. I mean, it's a significant legal issue affecting of major importance. Yeah, all those little factors. It checks all those boxes. So whether they do or not, remains to be seen. We'll find out soon enough. And look, even if they agree to rehear it, there's no guarantee that they're going to overturn it. But I would just think like, man, on such a case of such huge significance. And then you've got a United States Supreme Court decision that came out and said, hey, what you're doing here, it's illegal. This is not proper. To not apply it to the Boy Scout case, I have a serious problem with that. And of course, the net result of all this is, you got tens of thousands of people that were abused in scouting, they're the ones that have to pay for these errors. Okay. They're the one. I mean, my clients are the ones that are having to pay for this bullshit. All right. And so I got a serious problem with that. And meanwhile, the insurance industry, they're on the hook. The Boy Scouts had unlimited liability coverage. We're talking more than enough liability coverage to pay every claim in full, 100%. The fact that those insurance companies are getting let off the hook, got a bad, that's not justice. That's just plain wrong.
Okay, hold on. I know you got a lot on your mind. I'm just trying to help the audience
Oh, no problem.
understand. So if the Third Circuit agrees to the en banc, then
Yeah,
it's like a redo almost. If they don't, then the next and final step
Supreme
is
Court.
the Supreme Court, and the likelihood that they take the case is not that great. They take very
No, it's not. I mean, you can never predict. I mean, the Supreme Court grants. I mean, I saw one statistic one time. Maybe 50,000 requests a year, and they might grant 100 to 200, something like that. I'm not even talking about all the emergency stuff, like with presidential stuff. They're busy with that docket too right now. If you might have watched the news the last couple of months, but yeah. So the Supreme Court's the last step, and but I would think that even in this case, there is a strong possibility that the Supreme Court would grant cert in this case, and for all the reasons I just mentioned. I mean, they just issued their decision in Purdue Pharmaceuticals, which, I mean, look, I thought that was going to be a 9-0 decision. It was actually 5-4, which was kind of close if you ask me, but still, as the losers on a 5-4 decision, I'll tell you, it's the same thing as 9-0. It has the same effect.
Yep.
So yeah, how Purdue is going to be applied moving forward. There's all sorts of novel issues there. And I'm not a bankruptcy practitioner, so I can't give all the right lingo on that. But from what I understand, Purdue is a sea change, certainly in the way that a lot of these mass tort bankruptcies have been done in recent years. And I believe the Supreme Court, the fact that they took the manner in which they granted the petition in Purdue Pharmaceuticals was interesting. In that case, the Second Circuit upheld the confirmation order in Purdue, which actually reversed the district court. In Purdue, the district court said, no, you can't do that. The Second Circuit came in and said, no, you can. And then at that point, there were no other objectors. I mean, Purdue had gotten basically all the plaintiffs, all the states and the different groups of claimants to agree. There were no more objectors. The U.S. bankruptcy trustee stepped in and did its job. Okay. The U.S. bankruptcy trustee, that's Harrington. Harrington filed an emergency motion with the Supreme Court for them to stay the mandate. The mandate is whenever the court issues a decision, it doesn't just go into effect right then and there. They issue what's called the mandate. And at that point, when the mandate issues, that's after, the appellate, timelines have run, then they issue that. It's a formal order. At that point, then you affect the decision of that court. So Harrington submitted that emergency motion to the U.S. Supreme Court, and the Supreme Court granted it within minutes. And not only did they grant it, and that motion was it wasn't a petition to hear it. They're saying, we just want to, stay the mandate so nothing goes into effect, Your Honors. And the Supreme Court said, yes, well, we're gonna grant your stay, and we're gonna treat your motion for stay as if it were a petition for certiorari, which is basically, the big brief that you file to the U.S. Supreme Court to say, Mr. and Mrs. Justices, we think that the Supreme Court should hear this case because, and you lay it all out. So the Supreme Court they were watching this case, the Purdue Pharmaceutical case, from the outset. So, which again made me kind of think that it was going to be a unanimous decision, but it wasn't. But still, they ruled that third party or so-called non-consensual releases, that's not proper. Basically, you can't game the system like that. You certainly can't game the system like that in a case of this significance. I mean, you're talking again, talking what 60,000 victims of childhood sexual abuse. That's, I mean, and you're going to give them 5-10% of what you promised them in the first place. That's just wrong. Oh, and then there's enough insurance to actually pay everybody in full. And what are they getting away with? Paying, five, not even 10 cents on the dollar. It's wrong. It's like, how did we get here?
Yeah.
We back to litigation finance.
All right, well, that's why we're here talking about this. All right, so what we've learned, I think, in the past decade is just how problematic sexual abuse is. And all right, you had like 80,000 Boy Scouts that were sexually abused, but it wasn't like there was 80,000 abusers. A lot of the sexual abusers were repeat offenders who the church or the Boy Scouts knew about, and one case would come up, they would settle it, and of course, they would settle it confidentially. So, oh, well, we can't reveal the fact that this one Boy Scout leader has molested 20 people. We're not going to let the public know that. And that is a horrible injustice. And that's where, Curtis, you come in. So let's talk about your advocacy efforts and your advocacy successes, because sexual abuse, we need to correct this. We can't have institutional
Yep.
sex abuse. Like we shouldn't have sex abuse at all, but the institutional sex abuse is a major problem. So, Curtis, how are you doing? I know you've waited a
Great.
while here. We just want to
That's
kind of
okay. I
go
love
from the law
Jason's.
to advocacy. So
Yeah,
you,
Jason's got a lot of facts. I just soak it in when he preaches, so I love it. Um, Basically, we did have a recent in Texas and Missouri. Those are really horrible states for accountability for child sex abuse with these institutions, and we were successful. The governors just got a sign in both states, Trey's Law, and that's treyslaw.com is if you want information, where it eliminates NDAs that cover child sex abuse claims. And
Non-disclosure agreements.
Yes, thank you. And in Texas, that's where we're headquartered, where I'm at, my home state. And we went through the entire process, the Senate and the House, zero, zero votes that were no. It was 100% unanimous to go through. And the legislators called out institutions like the Boy Scouts and SBC, Southern Baptist Convention. They saying like, look, you cannot silence survivors. They got to heal. They need to be able to go to therapy and share without being afraid of getting legally in trouble. And you can't hide these criminals. So it was great to have that eliminated. It's making progress, and we're trying to. There's a great team behind it that you can find out again at treslaws.com, and I'm happy to help them as a survivor because the Boy Scouts did hundreds of NDAs silencing survivors and bearing claims. And I'll just say one last thing because I do want to take breaks to let you interact and everything. But over 115 years, they had thousands and thousands of perpetrators hidden, and they never reported them. They never did tell the families or the community when they found out something was going on. And there's been research. The 82,209 claimants is because they buried it. And then we finally said, hey, this is our chance with the bankruptcy. And I've been fighting that for 40 plus years. When I moved out, I was 16. I'm 56 now. And I've been fighting for getting them to be held accountable. And I'll just say that there's been some very good research that people have died or just not come forward. And they believe it's over, like 300,000 Boy Scouts. So, and they're 150, since 1910. Anyway, it's much more than the 82,000 that have been sexually abused. Yeah.
okay, so NDA is the same thing as like a confidential, a non-disclosure.
Yes.
All right.
Yes.
So, but who knows how many NDAs in the sex abuse world are out there, and these sex abusers are just, yeah, all right, whatever. My employer paid my bill and told me not to do it again, but who cares? I'm going to go ahead. Nobody knows about it. So, what about the past? What about all these NDAs that have been signed in Texas and in Missouri? Are they going to be still NDAs, or are they no longer NDAs?
Well, from my understanding, and I'm not an attorney, but working with some great people. But in Missouri, I don't think it's retroactive. In Texas, it's 100. It's like the most bold, solid. I just think it eliminates everything with the NDA hide. Now, NDAs are good if it hides the privacy of the child, if they don't want to come public, or it hides the amount of the agreement and everything. Things that are respectable, but it can't hide the crime, and if the survivor wants to say, John Doe at this camp or this Boy Scouts master, they need to be able to share that if that's what it protects other kids.
That's been part of the problem for so long, and why this was able to,
Fester.
basically be, to go in front of everyone's eyes for just decades and decades and decades. And I think, I was shocked when I started to realize the prevalence of pedophilia and childhood sex abuse. It wasn't just, in these little pockets here in this state, or, and I'm very Catholic. Everybody knows that. I've got 3 priests in my family, 2 great uncles and an uncle, one of whom was abused and is very vocal about it. And yeah, you've seen this everywhere. And now that we're going through, when we look at our Boy Scouts cases, we got cases in every state, several U.S. territories, and this was a widespread. This was not an isolated occurrence. Yeah. And when you start talking about the abuse, and fortunately, I was never abused when I was a kid, but for the grace of God. But you're not just talking about the damage to that person. Many times they never get over it. Okay, it's the effect that has on every person in that person's life. Yeah. Relationships. How much has this caused society? I've ventured to guess that if you went to just about any jail or prison in the United States, you'd find that a substantial percentage of the incarcerated prisoners in this country were sexually abused when they were young. And who knows what happens if they were never sexually abused? Would they still be in prison? Who knows? But right now the country's going through what you would call a reckoning of sorts. And this Boy Scout settlement sets back those efforts a good 2 decades, at least.
Okay. Back to you, Curtis. Trey, you keep mentioning Trey.
Mm-hmm.
What
Trey
is
Carlock.
Trey, and where does the name come from?
Thank you. I should have said that to begin with. Trey Carlock was at Camp Kanakuk, which is 100-year whatever entity as well. It's very similar to the Boy Scouts, so just not as many people. I think it's like 20,000 or so people have gone through the camps and everything for almost 100 years, and they've hidden. Missouri. They have other locations, but Missouri is the main one, and that's a pretty traditional thing for people to send off their kids, like Baptist church, to go away for a week or whatever. And it's like the Boy Scouts. I'm sorry, I'm going on, but it's like a cult. People just think like, oh, the kids will love it, they'll be safe and everything. But then you start looking behind the curtain, and you realize, oh my gosh, they've had, I believe it's 17 children or victims. They died by suicide, and there's been hundreds of children that have been harmed, sexually abused, and there's I don't know the number. I think it's over a dozen, almost 2 dozen. It might be like 19 perpetrators that have been arrested. Pete Newman, he got sentenced for 2 life sentences plus 30 years. Which was Trey. So basically, it's named after Trey because he basically couldn't tell anybody, even in therapy. He wasn't sure, and he suffered with not being able to heal, and felt silenced. Like they controlled him, is what he had said to his therapist, and it was shared with his family. The family couldn't even get after he passed away, couldn't get access to the NDA. So it's just harm, the families, the communities, and that perpetrator kept going around, like they do. Yeah, they get buried.
Yeah, from what we understand, Trey felt like he was bound by the NDA. Right. That's a pretty strong language in it for the consequences of breaching it, and that did not allow him to get the help that he needed to get past it. And that's very common.
Yeah, and that's the thing, is they wouldn't.
And Trey ended up taking his own life. in
Yeah, I think that
2018.
the family doesn't even know what he signed ultimately because they weren't involved in that. It's not like parents sign it for the kid in that case, which happens, but Trey had signed it, and they're like, "Wow, it wind up signs him to his grave is reality and what they say, and they don't even know what the paperwork has." So hopefully that'll happen where that gets released.
And you
If it's
mentioned
Missouri, yeah,
and you mentioned Trey's family. Trey comes from a wonderful family up in Dallas,
yes,
very God-fearing, very accomplished family. And Trey's got a sister, Elizabeth, who you do not want
yep,
to mess with.
yes,
Elizabeth,
champion this all the way.
Elizabeth has
Yeah.
been the driving force behind Trey's law, and she and the Phillips Foundation have really put together a team, and man, it is impressive. I was with them in Austin, talked to a lot of legislators, Senator Paxton, who was wonderful. Curtis and I were there.
Yes,
Very formidable,
yes,
very formidable force of nature, this Elizabeth. And that's
yeah,
the reason why Trey's law, despite people gave this zero chance of passing in
right.
Texas and Missouri.
Right.
Both
And
and
SBC
yeah,
did fight, we've had a lot of resistance, and the legislators stood forward, and Angela Paxton, Jeff Leach helped lead with Elizabeth, building a team that is just unanimous all the way through.
Yeah,
and
I
I'll
would
tell you,
ask you what SBC's argument was, but I don't even really want to know. It's so
yeah, right.
despicable to even think that
They
they would
all
show
got an
their
argument,
face.
man.
All right, so are there other states? We have Texas and Missouri
Right.
that have done the right thing, shockingly. Are there other states that this might go
Yes.
through?
If you go to tradeslaw.com, you'll see there is a map that says state laws where it shows that a version has been passed in Tennessee. And there are similar activities in California and Florida. Um, uh, and it's just the significance is Texas and Missouri, and the fact that Texas is the one that's really rose. The bar has been risen, and hopefully that'll start going across the nation as they keep pursuing this.
Is there any way that, let's just say, an ordinary person here that maybe just is interested in the whole discussion or whatever can reach out to their legislatures and say, hey, look what they did over here. It needs to be
Yes.
done here?
Oh, absolutely. And we do have people, even in Canada, I think recently, we're saying, hey, we really want to look into having some of this addressed there as well. So it's more than it's international, but the thing is they have social media. Trey's Law is on like all those social media platforms: Instagram, Twitter, X, Facebook, and people are always asking, like, hey, is this possible in my state? And hey, can you guys tell me how to start preparing for the next legislation session? In fact, the next legislation session in Texas, we tried it this time with the statute of limitations, but we're going to have to, that's the same kind of effect. It silences survivors. And it's Trey's Law is specifically about the NDAs, but it's also, they're also looking at doing what they can with this statute of limitations.
Yeah. All right, guys,
There's
that's
a good
been a
chance.
lot of information. I know I've left a lot on the table here. We're going to come back again, when this gets finalized in the appellate courts. And Curtis, you'll give us the updates, and we'll go more into the statute of limitations. Unfortunately, life is the present and the future. So,
Right.
we're going to try to use this platform here, maybe to get some legislative help, because there's a lot of victims out there. People you might even know, people out there you don't realize that maybe you
Mhm.
might be talking to somebody who's been victimized and they can't even talk about it. They can't. What's going on? What's wrong with you? I can't talk about it. I'm under an NDA. It's just a horrible situation. But I thank both of you for coming on today. We're going to do
Thanks
it
for having
again,
us.
Jason. I know you want to say more.
Uh,
You're going to have your opportunity. I'll let you have the last word, but not today. That's
thank
going to
you,
do
Lord.
it for this episode of Cut to the Chase. So the Trey's information is going to be, you're going to have to go to the audio podcast. I'll put it in my show notes so people can look into it and do something about it. Okay. It's not just getting educated. I want people to take action. CTAs. All right. We all know call to action. This is the call to action is take action on this. All right. And if you're watching on YouTube, you can leave comments, questions. I know that it's still very complicated, hard to understand how there could be a settlement and an agreement, that has been voted on. I don't even know. All right, I'm not even going to get to that. All right, that'll do for this episode. Again, thank you guys, and we'll circle back in a few months. All right.
Thanks,
Thanks
Greg.
again.
That's all for this episode of Cut to the Chase. But before you go, will you open up your podcast app and give us a 5-star review? You can also leave a comment about what you liked most or other topics you'd like us to cover. And please be sure to subscribe so you don't miss any upcoming shows. Thanks, everybody. Be safe out there.